Hi, in this week 2 of Knowledge November, I want to talk a little bit more about the implied term of trust and confidence that is in every employee's contract of employment. So it's something that the law reads into everybody's contract, and it's more of an issue for the employer than for the employee. So it's about the employer not overstepping a line, a threshold, which enables the employee to say enough is enough. The way you have behaved is so bad. I can't be expected to tolerate this. So that is there kind of as a protection, I suppose, from the law to the employee, that employers shouldn't go below a certain standard of behaviour towards the employee. And you can break down trust and confidence cases into two kinds. So classic, if you like, good old-fashioned trust and confidence is about that reprehensible behaviour by the employer that destroys the relationship between the parties. So what they've done is something so bad that it justifies the employee saying, I can't continue. The language in the cases talks about things like acting in a manner calculated or likely to destroy or seriously damage the employment relationship. So there's a balancing act for employers always to be able to say, well, there's a really good reason why we've done this thing that the employee is accusing of. This is the context, this is the background. Judge, please don't decide that we've fallen over that threshold, because look at all this reasonable background to the situation. The second kind of trust and confidence scenario is where the employer is exercising a particular contractual power or a discretion that they've built in. So it might be around payment of bonus or sick pay, or something like when pay rises happen. And the courts import what we call braganza, from the name of a case, duties onto the employer, so that when they're exercising that discretion, there's going to be a burden on them to not behave in such a outrageous way when they do what they do, that no reasonable decision maker could be said to have reached that conclusion. So there's always going to be that burden on the employer to set out what the process was that they followed, any criterion that they used. So for example, if it's the award of a bonus, how did this year's bonus get awarded? What criterion were we using when we were deciding who we were going to give it to and who we weren't, etc. So I'll give you an example of a case where somebody was found to be constructively dismissed for the employer not being able to get over those hurdles. And that was where the employer decided to give everybody an increase in their pension, except for some employees who were members of one particular union that they were not very favourable towards. So that would be an example of an employer stepping over the line. There is a Court of Appeal case called Leach and the Office of Communications, where the Court of Appeal is cautioning against employees being able to invoke breach of trust and confidence or allege it too readily, saying, it's not a convenient label we can stick on any situation. There is this sort of threshold that the employee is going to have to get over to show that something really bad has happened. But to give you some sort of examples of themes again that I often see, where processes are in train. So it might be a grievance process, performance management process, the redundancy process, disciplinary process, sickness absence management process. If those processes are conducted in a way where an employer is, getting the basics wrong of those procedures, if you like, and carrying them out in a way which, reasonable employers wouldn't be doing it that way, that's where I think employers can find themselves in difficult territory. So if things are done with, ineptitude, then an employer is risking getting into that territory. So, for example, if it's a redundancy process, not looking at alternatives. If it's disciplinary, it might be rushing into making allegations without any, investigation being done, would be an example. Again, we talked previously about health and safety and things like that. I think we've learned a lot in the last year around psychological safety in the workplace and COVID, and anything that makes the environment not safe for the employee could come up here in constructive dismissal terms. So could be around COVID, but it could also be bullying and harassment. I was dressed down in front of all my colleagues by my manager, who shouted at me in front of a room full of other people. Those sorts of situations. Issues around stress and workload we touched on previously, they're all going to come in here. Not taking reasonable adjustments seriously in terms of your duties to disabled employees. Could even get into this territory if, while somebody is, for example, off sick, you start threatening them about the fact that there have been complaints or there are concerns about their performance, that sort of territory. Now, I'm a believer that we have to be open and honest with people. So if a complaint from a customer has come in and we are investigating it, I think we would be remiss to not be telling the employee that that's what we're doing. But we've got to be really careful not to stray into that territory where we're weaponising what we're doing and potentially making the employee's health situation worse, etc. So, you probably need to get some advice around that kind of situation. Hopefully that's given you some more examples of when you might get into constructive dismissal territory for breach of the implied term of trust and confidence.